Okay, so my name is Irini Bekhit. I am the supervisor of the Guardianship Department in the Surrogates Court of Richmond County. And I've been the supervisor now of that department for about 2 years. And it's kind of like Judge-Seton came in about 2 years ago. Prior to that, I worked for Judge Gigante, but I was doing other things. I've been in the court for about 10 years now. So when Judge-Seton came in, we had a talk and we said, you know what, he's new, I'm new to guardianship. We're going to learn this whole thing together. And what was great about that is it allowed me and him the opportunity to kind of talk to a lot of different organizations, listen to parent feedback, and then change the system from what it was to kind of make it more streamlined and have the process as easy as possible. But we also, as the court, we have to make sure that we're also keeping in line with what the laws say, what the statutes say, and that's the most important thing. So what we have developed, and I'm going to share that with you, I'm going to share my screen in a couple of minutes, is prior to COVID, actually, in December of 2019, seems so long ago now, we started these information sessions, guardianship information sessions. And so twice a month, we'd have people who signed up ahead of time come down to the courthouse, and we would go over the guardianship process from the point of view submitting papers, from actually going over the paperwork, from, and telling you about the fingerprints and the background checks and all that stuff and the hearing and all that. So from A to Z, we would go through that. So we started that in December of 2019, and our numbers of attendance kept increasing tremendously. And then in March, as you all know, Corona hit and kind of the world stopped. And so we had to cancel all future guardianship sessions. But a blessing in disguise was maybe a month into it, I made YouTube videos of the whole process. So there are now YouTube videos, and I'm going to share that with you in just a couple of minutes, where we break down the guardianship information session. So the session I would have given in the courthouse to you is broken down into 4 segments. The first is overview of the guardianship process, so you have a general idea of what you're expecting. The second part is alternatives to guardianships. That's something new that we've done that I don't know how many other courts do, but we want to tell you all your options, all the options that exist, not just 17A. Why? 17A is the most extreme type of guardianship in the state of New York. So for us to implement it or for us to grant it, it means that there's no other less restrictive means. And so before we take away somebody's constitutional rights from now until the end of time, we need to make sure that it's warranted. Let's say that, you know what, 17A is the right avenue for you. Video number 3 is going through the paperwork line by line. And what we also did was we created mock forms. So you get an email that has the mock forms. You have a video that goes through those mock forms section by section. And what's great about having it, as a video, you can pause, you can rewind, you can start it today, finish it tomorrow. Okay. So, and I think video number 3 is the longest one. It's like 45 minutes or maybe a little bit longer than that. And then video number 4 is commonly asked questions of things that we get. And the mock forms, I know that 17A petitions, if you've even started or attempted it or looked at it, it could seem very overwhelming because it is a lot of paperwork. But I will tell you, you can certainly go to an attorney, and that's fine. An attorney's going to charge you a couple of $1,000s. That's completely up to you. You're still going to have to provide the attorney with the information that you already know. So you might as well just fill it out yourselves. Just be a little patient. I'm sure you're all used to filling out a lot of paperwork. That's all it is. It's paperwork. It is a petition for guardianship of the person, and the videos just concentrate on the person. When you have property, I'm going to talk about that a little bit later. It kind of there's a different dynamics that we have to be careful of. So there's that petition, the original document. You have the affidavit of proposed guardians. You have the documents that the physicians have to fill out. But all those papers, we also give you like a terminology sheet, like when I mean petitioner, who's the petitioner? What does respondent mean? All in plain English. What do you have to actually submit to the court when you're ready to mail it in? What's the filing fee? Where is it going to go? All that good stuff. It's in that. And what I'm going to do now, I'm actually going to share my screen with you. That way you can see. Your first step, if you're actually going to file, is just to contact us. I'm going to put in the chat box right now my email address. That way you have it at nycourts.gov. Your first step is just email. I could give you my direct line as well, but honestly, I don't check my work line as often as I check my email. My email comes to my laptop, which is I'm using now. It comes to my cell phone. Like I check my email at all hours of the day and night. So if you're interested in pursuing guardianship, your first step is just to contact me. And then the guardianship department is just made up of, right now, it's only 2 people, myself as the supervisor, and I have somebody that works in my department. And she's going to be your point of contact for the most part, because what happens is I get the email, I send it to Alex. Her name is Alex. And she will then send you this email, which I'm going to now show you. Hold on, where is it? I think this is it. Okay, so you should now be able to see my screen. Okay, and my screen, as you can see, here is a cover letter, right? Here's the terminology sheet that I talked about, which is, what words mean that maybe I'm using or that are in the petition. The blank form that you're actually going to have to fill out. The fingerprint forms, and I'm going to talk about the actual background checks in a few minutes. The Mach 17A form. So the entire petition and all supporting documentation, the blank ones, we're giving you Mach forms. So everything there. And then we have like the word mom, dad, not applicable, only if you need it. Like we spell out in the little margins, like what you have to put in. If you need it, fill this part out. And then here it's Mach 3909 form. That's also part of the background check. And so and then here you also get the link to the videos. So as you can see, video number 1, general overview. Video number 2, alternatives. Video number 3, review of the paperwork. And number 4, commonly asked questions. So everything is there for you. And I will tell you that the feedback that we have received from families has overwhelmingly been, if you are actually going to take the time to watch the videos and look at the forms, so it's much less time going back and forth for us to tell you fix this, fix that. The product we're getting back is in a lot better shape, so we're able to take it for filing, because if it's not in proper form, we can't take it for filing, right? One of the other things that we've done is the system, the court system, while it can accept certain filings electronically, guardianship has not been made one of them for the court system yet. So you're going to have to eventually mail in the hard copy and all the stuff. But as a courtesy, what we do is we allow you to email it as a PDF document. So once you have everything, if you have a scanner at home, you can scan everything before you get it signed and notarized. Why? Because then we can review it. If there's anything incorrect or needs to be modified, we can tell you, on the petition, go to this page, this section, this needs clarification, this is incorrect. We tell you to fix it all up. Once you fix it, then you can get it signed and notarized. And then you're going to mail us a package, all the forms with your $20 filing fee, with the original birth certificate or a certified birth certificate, which you do not get back. That's also in the paperwork. The physician affidavits, you need 2 of them, also in the paperwork. It could be 1 MD and a psychologist, or 2 MDs. That's statutory. Okay, can't change that. You put all that stuff together and you send it in. When it comes in as a pro se from an applicant, meaning somebody without an attorney, we will prepare the citation for you. I'm going to get into citation later. We're going to prepare the decree for you. I take care of that. You don't have to. So it's really just submitting all that paperwork. Once we have the paperwork and it's in proper form and it's signed and notarized, then the next step is, all right, I'm going to review everything. Alex looks through to make sure everything is procedurally correct. And then once the medicals are in, I review the medicals. Right? I'm going to review to make sure that this is in fact the 17A. If it is questionable, if it's a borderline case, I'll contact you and we're going to schedule a conference just like this. It's not Zoom though. We're not allowed to use Zoom for work. after work hours, so I can do it. It's using Microsoft Teams. And I send you a link, and I will talk to you as a parent, and I will talk to your loved one, whether it's your son, your daughter, niece, nephew, grandchild, whatever it is. And I'm going to ask certain questions to determine, before we get into the background check, before we get into all that stuff, whether or not this is the proper court. And the reason we do that early on is to save time for you and for me, right? I had one of the first cases that I came into was a person had spent an entire year doing guardianship, getting paperwork, doing all that stuff. And then I looked at it, and it was all, the diagnosis was like schizophrenia. It was all like psychological based. It had nothing to do with what the statute enacted. It wasn't properly in our court. And so that's why I look at the medicals early on. If by looking at them early on, then you're not doing the fingerprints, then we're not doing the 3909, now we're not scheduling it for a hearing, we're not issuing out citation, we're not doing those things if we don't need to do. So let's say it is again properly in our court and everything is fine, and it belongs here, the medicals check out. I'll call you and we're going to set up fingerprints. Now, the fingerprint process has changed with COVID. So for a period of like 6 months from March until October, we weren't allowed to do any fingerprints. So any petition that came in, it was kind of on hold. Then I got the notice because I was checking with the fingerprint. When can we do fingerprint? When can we do fingerprint? And then we're like, okay, you're allowed to do it. I was basically allowed for the month of October and November, and then we shut down right before Thanksgiving. And I was only given 2 days with one family a day. Okay. And so right now, our current status with fingerprints is that it's also shut down. Does that mean if you have an emergency and you qualify for 17A and you need the authority because your loved one is having surgery and you need this, does that mean we're not going to be able to help you? No, it doesn't. We'll be able to still help you. There's other avenues we can pursue, temporary guardianship, if there's an emergency, but you must establish that there is in fact an emergency and you require it, but we'll help you with that. So 3909 and the fingerprint are the two background checks that we need to do. The 3909 form, also in there, we recently, and it's in your package now, we recently created a Mach 3909 form. It's the most difficult form out of everything because we have to have a 28-year history of where you and everyone in your household has lived. So what we did was we came up with a Mach family. We listed down in plain English where mom and dad and kids have lived. Grandma lives with them, right? So she's in the household. She has to be fingerprinted also. So we give you a plain English scenario of a family, and then we translate that onto the Mach 3909 form. That way you can look at it and then you can fill it out. But let's say there's something wrong when you submit it. Is it the end of the world? It's not. You know why? Because if there's something wrong, Alex will call you up. Sometimes we've resorted to FaceTime, right? Where it's like, all right, we're on FaceTime with you and we're trying to get you to fill it in properly. If it's like worst case scenario, we'll make the changes ourselves, but we really, that's not something that we want to do because we don't want anybody to say, well, it wasn't my fault. I didn't do it. It's their handwriting. So as much as possible, it's your responsibility, right? You want to be the fiduciary. So we just try to get you to do everything in the right order. Once everything is filled in, your fingerprints have been taken, we get that back if everything is clear. The 3909 form, that background check, which is with the child services, child abuse services. Once we get that back and everything is okay with that, then all right, I'll give you another call. It's now time to schedule your hearing/conference. Because of Corona, you're not going into the courthouse anymore for the hearing. It's not going to be before the judge. I'm doing it. So you're basically dealing with me, the same person who now knows your case from beginning to end. You're not going through a million different departments, which is how it was in the past. It was going from the help center to the clerk's office to the court attorney referee to the guardianship department to the surrogate to the police officers for fingerprints. It was going through all these different people, right? So every time somebody picks up your file, they got to look at it from beginning to end. It's just me and Alex now, right? And I'm looking at it from beginning to end. And we're in constant communication with you if there's anything that's outstanding. So now you're ready for the conference. I'm going to give you a call and I'm going to say, all right, right, let's schedule this. When is the best time for you? Because I'm going to need to see you. I'm going to need to see your child, and I'm going to need to see if you have a co-petitioner with you. You all need to be at the same time together. Now, with technology, you don't even have to be in the same room, right? Because if you are petitioning and your husband or your ex-husband lives somewhere else, but you both want to be co-guardians, there's no problem. You just send him the link or you send her the link. They can sign up from wherever they're at. You sign up from wherever you're at, and I will be able to talk to you. We select a date and time that is works for you. If it's a day that I'm working from home, I have no problem. I've done guardianship, conferences, which is the final step, the hearing, as early as 6 a.m. and I've done it as like late as 7, 8 o'clock at night. So it's fine. It's not really a big deal. And it's whatever kind of works for you. If you're all in the same, if it works for you, then it's fine. I've gotten the judges okay to do it. There's no union issue. There's nothing like that. There's no, it's it's completely fine. And then we have the conference. I ask a multitude of questions. The questions are not directed at you, but more so the person you're trying to get guardianship over, where I ask them a number of things. And I actually skipped a step. When we select our date for the conference, you have to serve something called a citation. And we prepare it. We prepare the citation. You get the citation via email. What happens is I send you an email that has the link that you're going to be joining for our conference date. In that, you'll get the citation, you get directions on how to serve it. And I even made now the most recent thing, I think I did this like last week, a mock affidavit of service. That way, you know the document you have to send back to me and how to fill it out. Because again, I do this all the time. I do this every day. So I know what an affidavit of service is. I know it has to be filled out. But if you're doing this one time, it may not be as easy for you, or the terminology may not like click for you. So now you have a mock affidavit of service. It's the only document that you have to submit. Once I have the affidavit of service, then you're kind of good to go from a procedural standpoint. So now the conference date comes, I click on, you click on, and I will talk to you, and I will talk to, again, like I was saying before, I will talk to your respondent, the loved one, the person you're trying to get guardianship over. And I ask a multitude of questions, right? Because I need to gauge whether or not this person whose rights are going to be affected until the end of time understands what's happening. Is it warranted? Is this the least restrictive means? Is it something we should do forever, or is it something that we should do for a couple of years and then revisit? Okay. When I have an application, and sometimes parents want to kind of like talk and say and ask whether or not this is the proper course. I had one mom said, my son is attending college courses right now. And once she said he's attending college, it's kind of like, this is really not the proper, avenue for you, because he's attending college. He's able to go. He has like a 3.4 GPA, 17. You may not agree with his life decisions, like the choices he's making, but it doesn't mean that the court should substitute his judgment for yours for the rest of his life. It's not warranted. And so, that is not the least restrictive means. If you have a concern about your loved one's ability to make decisions, whether it be financial or health, there's other less restrictive means, like a power of attorney, like a healthcare proxy. And with those documents, it's like they are good unless a court says they're not good. So once a person turns 18, if they're able to articulate and say, I want my mom, I want my dad, I want my uncle, aunt, grandma, grandpa to make my healthcare decisions for me, then you have a healthcare proxy that does that. You have a power of attorney that takes care of finances. And so those are the documents, and possibly Article 81, which is a proceeding done in Supreme Court. So it really depends on your situation. We look at every situation. I read every document, and sometimes I find it's funny because I'll find inconsistencies, usually when it's drafted by an attorney rather than it's what's done by a pro se, because I look at what the medicals say and I look at what the petitions say, and sometimes things are contradictory. So it's like, you know. um and so that's the process. After we have our final conference face to face, then I will kind of tell you, what my recommendation is to you as the family coming forth, and I will tell you the recommendation I will make to the surrogate, you know. And after that, you'll get a decision via email. We don't do hard copies anymore. And it'll tell you, all right, you're made guardian, here's the letters, here's the authority, or it's temporary. Um, I haven't seen one that has gone that far where it's going to be denied, because by the time you're getting to that point, I've already filtered it out. If it was something that I wasn't sure about, if it was a borderline case, we would have had a conference early on, or I would have told you that this is not the right avenue. So if you're getting to the point of that conference, it's either, a temporary or a full. Like I said, I haven't seen it yet. You might be the first to stump me, and where we're getting to that point, but probably not. The last thing I'm going to focus on and kind of just tell you is the property aspect. The reason the focus is on guardianship of the person is because if you have property that you're trying to become guardian over, we're very limited in what we can do for you. And I'll tell you why. If your son or daughter is getting some kind of inheritance and you want to have guardianship over that to make that a an asset that you can now control, we don't get involved with that. Why? Because you should seek the assistance of counsel to determine whether or not there are implications on any social services that they're getting. Do you need to create a supplemental needs trust? That's, and I'm not gonna, I can't, I can't give you legal advice. I'm not allowed to give you legal advice. My legal degree is for the court. It can't be used for any type of, advice or anything like that. So if your child is receiving Social Security, that is not considered guardianship funds. You are the payee. So that doesn't have to be under our auspices, if you will. Why? Because if you're asking for guardianship authority, what happens is we become joint holders of the funds, not me. It's like the chief clerk. And so you can't access that money unless you make a proper application to the court. And it's up to the judge to decide whether or not he's going to allow that to go forward. So it's jointly held with the court. It's a lot more restrictions on it. But again, the biggest issue is whether or not you should even be just having money out there that your child has is considered entitled to, or whether or not you need to pursue and look into a supplemental needs trust if they do have a disability of some sort. So that's really the one thing that we don't touch, and we can't, we're kind of limited in what we can do and help with. The property aspect. If sometimes you right now, like, you're coming in as co-guardians, two people, and you have other children, you want them to be like step up, right, to be standby, god forbid something happens to you, but they're still under the age of 18. Don't worry about it. You can go through the process. Once they turn 18, 19, 20, you submit an affidavit explaining who you want. We'll give you the proper forms that have to be filled out, and then we amend the decision and say, okay, well, here's our two guardians that were appointed in, the year 2020, and now we have so and so as the standby, so and so is the first alternate. What if you named people now as, standby, first alternate, second alternate? 20 years from now, they turned out to be the worst people in the world, and you want to remove them. What can you do? Well, you need to give them notice. They have to consent to it. And then you'll tell us who the new people are. Whether I'm going to be around, whether the process will change 20 years from now, I can't really say. But it's, the first step is always to just call the court and kind of just talk to somebody there. What's the best, I think, about the whole guardianship feel is, this is not an adversarial process. We're not trying to trick you into anything. We're really just trying to get you to meet the hurdles that are necessary legally so you can get to the point where you want to be. And speaking of it being, adversary, if you're filing for a petition and you have a family member who's an interested party that is contesting it, we take a step back. Then we can't help with anything. Okay. So again, when is this the most often case? It's when we have two people that are divorced. It's a contentious divorce, and one person is not happy with the other. And so if it becomes a contested, this person wants guardianship over this person. All right, well, each of you now have to kind of get your own attorney, because this is going to involve discovery. This is going to involve a much more contested feel to it, where we can't just kind of help you. And that's pretty much it. If you have any questions right now, I don't know if I can unmute you. So just try to unmute yourselves and go ahead and ask.
Do you have to get an ex-spouse's permission, or do they have to give up something?
So it depends on the situation. If you know where your ex-spouse is, then they're supposed to do a waiver and consent. That's the easiest thing. Once we see a waiver and consent from the father or the mother or whoever is on that same line of relationship, if they give a waiver and consent, it goes through. Let's say you're not on the best of terms with them and they're not going to sign off anything to you, then we have to cite them. So that citation that we send out, that point where you have to serve your son or daughter to give them notice of what you're doing, you would add your ex on there, and then they have an opportunity to contest it. But once we know that, again, we kind of have to take a step back. We can't be your advocates, because it could be a potentially contested matter. The third and final scenario is the statute, the law does allow us to forego service or notice on someone if they have been absent from the child's life for a number of years. But you would then have to submit an affidavit swearing to the truth of that by saying, I haven't seen my ex, the father of my child, in 20 years. He hasn't been around. He hasn't been involved. He hasn't done anything. I don't know where he is. And then the surrogate, I'd have to bring it up to him. And then he would kind of say, all right, we don't have to, pursuant to that section of the law, we don't have to make you jump through hoops to find where this person is and give them notice.
And there could be two guardians.
Yes, initially there could be two guardians. Yep.
So if my ex-husband signs a waiver, I could be guardian and one of my other children that's over 18.
Yeah, as long as your ex consents to that. So
right.
If he signs off, because like the waiver that he's going to sign off is going to say that it's Stella and your child, the one that you want to be guardian,
right.
I'm consenting that they are acting as co-guardians. Maybe he's a standby, maybe he's a first alternate. The forms actually allow you to have up to two co-guardians. You can do, I've done it where like I've had like a huge family once where we had two co-guardians, two standbys, two first alternates, and then they ran out of people. So then they had like one second alternate. You could have like, I don't know, 2, 4, 6, like 7 people kind of in your lineup,
But
so
co-guardians have to agree on things. So when there's decisions have to be made, it's better to just have standbys. So when I die, they step up, right?
So I haven't seen a situation where the co-guardians disagree on how to act. The statute, the law doesn't say that they have to. Each one has the authority. The problem you're going to have is if one guardian makes a decision, now the other guardian isn't happy with that decision. Now it becomes like a battle of the guardian. And so is it going to escalate to where the court has to get involved and determine the best interest, or is it something that they can work out on their own? But the statute doesn't say that.
Just to have it as a standby, as a backup.
I can't say if it's better or not.
Decisions
I'm not going to comment as to whether or not it's better. It's up to the family dynamics, and you know your family better. So if it's better for you to be the guardian and have somebody step up, if you're not around, and just as a FYI, you have 180 days statutorily, legally, 180 days, 6 months for the standby to step up and have that appointment confirmed. Otherwise, a new petition is required. So 180 days, 6 months for the standby to step up.
Once you put them as a standby, is that what you mean?
Yeah.
They have to agree to it, in other words. They just have to agree to be a standby within those.
Yeah, basically, like,
Yeah.
they have to step up and, like, assume the role within
Yeah.
180 days and then come to the court to say, hey, judge, I was already made standby 10 years ago. My mom is no longer in the picture. I'm now asking to be the guardian so I can make the decisions for my brother or
Oh,
sister.
okay. And that would happen when I can't make decisions anymore, something happens to me,
Correct.
and that's when they step up. Okay.
Correct.
Hello, I have a question about the medical forms.
Sure.
I pretty much did most of the guardianship. I had everybody notarized, had their papers and stuff. But I'm seeming to have a problem of the doctors filling out the forms the correct way. Because the first time I did this, I had everything ready. I think I saw Alex, and I went through everything, and the medical forms were all wrong. They weren't filled out correctly. And I finally took them back. I gave the doctor, my other two kids, the doctor's information. They filled out one set of forms. I still have to get another, so I have to find another doctor to fill it out.
I think, like, a doctor or a psychologist. I mean, at the school, if there's a school psychologist there,
Yeah,
that's
okay.
sufficient.
But also my son, my oldest son, who's now 25 already, I took it to his doctor and they keep filling it out wrong. They filled it out wrong twice. So I need to know.
Fill it out,
What I
just make
did
them
was
sign
I
it.
gave them, they filled out the part where they ask you for, I have reviewed the following documents
Yeah.
about like intelligence scores and all that.
Yeah.
And I gave them exactly what to write and they did it wrong.
Why don't you contact me? I gave my email address.
Okay.
Contact me afterwards. Send me what you have, and let's see what we can do to salvage it. If anything.
Oh, okay. And also, like the second doctor, I mean, I don't really have a second doctor. Maybe I could ask the school psychologist for the other two kids. My son's seeing a psychologist now, so maybe I could ask him to fill out the other one.
Yeah.
But that's the part I'm having trouble with right now.
Yeah. No, the school psychologist should be fine. We also require now under the new surrogate either an IEP or an ISP. So
Yeah, I have that.
yeah, so if you have that, like if I have a detailed IEP or an ISP, as long as like the bare minimum on the medical forms are filled out, then I can kind of use it to help.
I'll send it to you.
Send it to me.
And then
Yeah, I'll take a look at it.
Okay.
Irini,
Yes,
is
ma'am.
there like an expiration date for the forms for the medical doctor? Like, so my daughter's young, she's only 15. So
Wait.
I know, right, you can't do this yet, not until like they're 18. So at what age do you recommend getting like the medical forms
I
done?
would say like if you're planning on filing like, you know, right before she turns 18, then it should be within 6 months.
Okay.
Our local court rules prior to COVID would say that documents have to be 6 months. After 6 months, they're considered stale. I've
Okay.
extended it due to COVID, but you know, I don't want it more than a year old, right? Because a lot could happen in a year.
Right.
So they should be like, you know, as fresh as possible. Like
Okay.
once you have a petition, if a petition is signed and notarized and you have medicals, file them with the court. If there's other stuff that's outstanding, you can get it later. But as long as that stuff is filed, then I'm not going to say, okay, you know, get me these new things again, unless you spend like 2 years in between where now it's like just, you know, this is ridiculously long. You know, we need like fresh stuff. But if everything comes in within a couple of months, it's fine. It's not a
Okay.
problem.
Okay. Thank you.
You're welcome.
Do we do this right when they turn 18 or before they turn 18?
You
When do
can
we start
start it before they turn 18, but we won't accept it. If they're younger than 17, we're not going to accept it. It's too early because you can make all the decisions until they turn 18. So there's no need for a guardianship.
How
And
long does it take?
it depends on, you know, what the situation of the court system is. So there was, when we were doing fingerprints a couple of months ago, I had some things that were filed in September and finished by November. The turnaround, why? Because they filed it, everything was correct I didn't have to do any of the back. So everything was done. All the medicals came in at properly. I was able to schedule the fingerprint appointment.
Right.
We were able to do the background check. I got everything back, and now they're scheduled. Their hearing is coming up in like, I think, December or January, and those things were just filed. But right now I can't do fingerprints. So I have a whole backlog back of people that have to be fingerprinted. So that's the
But if I submit it when she's 17 and a half,
that's
and
fine.
everything gets done, you just hold on to it until she's 18 and it becomes official. You mentioned also we have to submit the original birth certificate and we don't get it back.
Correct.
What does that mean? We don't get it back?
You don't get it back. It's part of the court record. So either a original birth certificate or a certified birth certificate, and you can request a certified birth certificate from the Department of Vital Statistics.
Yeah. Oh boy.
Yeah, I'm in the process of that, Stella. I could send you the link that I use.
Yeah. I mean,
That's
I
the
think
only
I've done
document
that.
that
I
we
think
keep
I
that's
did it for
original.
me. I lost the birth certificate and I had to get it
You
certified.
can get as many as
Right.
you want originals. You can get.
Yeah. Oh, geez.
I actually ordered 3 because I think we need it for Social Security too eventually. So I just got extra, so I have them.
Oh, I didn't know you could do that. Okay. It's good to know. Yeah.
Does anybody have any other questions?
Thank you. That was very helpful. I was
Good.
overwhelmed with the whole process, but you made it seem.
Not that bad. It's
What
not that
I
bad.
did a
exactly
great
does
job.
guardianship give us?
I'm
No,
sorry.
What does guardianship allow us?
Well, that's your decision, really. Like, that's why we talk about alternatives. So guardianship allows you to make decisions and exercise your judgment for the person you're getting guardianship over. So if you're going to a doctor and, now your child is 19 and the doctor doesn't want to talk to you because they can just talk, they're supposed to be talking to that individual because they're over the age of 18. If you're the guardian, they can talk to you. But the same thing
Okay,
can be done with a
medical.
healthcare proxy. So a healthcare proxy, if they're not able to articulate their wants and needs, or if your son or daughter says, I want my mom here, there's no problem.
yeah.
So what
I went through
more
that with my
does
son.
guardianship give me than those other things, the proxies and the
That's the
power of
legal
attorney?
question of the century, really. It's some people feel more comfortable with it because it's a legal document that's authorized and stamped by the court. So it does have a weight in that respect. But again, that's why every family is different. Every situation is different. Whether or not it's warranted is the question that we analyze and kind of have to determine whether or not it's warranted. Because again, it's the most extreme type of guardianship. I will tell you, today I spent maybe 3-4 hours between reading certain documentation and having conferences with not only our surrogate, our judge, but another surrogate from upstate, because we have a guardianship where somebody was adjudicated as a 17A when he was 15 years old. He had Asperger's. He was not the process wasn't actually explained to him. He didn't realize what it meant as far as his rights and his decision making ability. He's now 25 years old. He drives, he works, he lives on his own, and he hired an organization to undo the 17A guardianship because it's not the least restrictive means. And so it's the first one that's
But
filed
what
in our court.
exactly does it? But what exactly does it undo? What is he trying to stop his parent? What I'm saying is, if I have a daughter who will never be able to make a decision on her own, financially, medically, and any decisions on her own, if I don't get guardianship, how would that hurt me?
Then
I mean,
maybe
ask her if she's
doctors.
gonna, they can make decisions at some point in their life. Maybe she will never make
Okay.
any decisions
So
on her own. So what happens if I don't?
Well, if you go, like I was saying, if you go to a physician and they don't want to talk to you because you communicate or they want to make the decision for your daughter, then they can, because you're not the guardian. You don't have the legal authority to make decisions for her. So if
But
you
the
go out
doctor
of state,
does. The doctor then has the authority
if
to make
there's a
that
life or
decision.
death decision, or if there is a decision that they don't, that, let's say
Just being a parent doesn't give me that right.
it terminates at 18. So once your child becomes 18, they're legally able to make their own decisions. And so you no longer have the right to tell them what to do because now they're adults.
But wait, you just said, but then how does that fit in with my typical children? they get into a car accident, they're in a coma and they can't make that decision, life or death decision. I don't get to make that decision, or their spouse
If the
doesn't. The
doctor
doctor
asks,
does. We don't have
they will.
guardianship. You
The
know what I'm
doctor,
saying?
okay, I'm trying to answer. If the doctor asks who the next of kin is, yeah. But if you're going something against medical advice, maybe the doctor then has the authority to make a decision that he or she feels is best for the child. If you go to the dentist, and I use the dentist as the best example, and you want to remove, the dentist says it's better for you to remove your child's molar, and your child, who now you have guardianship over, doesn't want it moved. He doesn't want to go through the process. He doesn't want it, but you want to listen to the doctor. If you have the guardianship, the doctor is going to listen to you. They disregard your child's wants and needs. But if you don't have the guardianship, they're going to listen to the patient and what the patient wants. So the guardianship gives you that ability. But again, that's why we as the court, if we're going to have to take away somebody's decision-making ability, it has to be warranted, because there's no reason to substitute your judgment for somebody else's. Yes, you're the mom. Yes, you have your best intentions in the world. You want to protect your baby for as long as possible. But once they turn 18, the law says that they can make their own decisions.
So other than medical, what other instances?
Those are the only things that we're only giving you. It's medical, like,
Okay.
it could potentially, when it comes to housing or things like that, we're not touching. If you're asking for guardianship of the property, that's separate. That's why I was saying that you're going to go to an attorney for that. If it's something little or, less than 10,000, we may be able to help you. If it's under 10,000, there's a provision also in the law. I'm not going to get into that. That's not the purpose of this evening, but if there's property involved, that's separate. But it allows you to make decisions for his person or her person. And the most common is medical. It could be about, it's not so much as contractual obligation if it has a property component. Don't forget, when you have a guardianship in place, right? And now this person you got guardianship over wants to get into a contract. They want to sign a contract for job employment. If the employer finds out that they, in fact, are under a mental disability and they do have a guardian, and now they want to actually void the contract, they can get out of it, because your son or daughter legally does not have the mental ability to enter into a contract. So there's implications that happen. Somebody under a disability, they can get married, there's nothing to stop them, and marriage is essentially a contract. But do your research. I'm telling you what we do. I'm telling you what the process is. There's philosophical discussions on every which way, and it's really up to you to make your most informed decision. I'm giving you as much information as I can, but I don't want, it's more than just filling forms. It's really knowing the end result and what you're trying to do, and you should be informed by doing your own research into a multitude of things before you commit to this.
The first time I went to the courthouse to have my forms looked over, the first time I went through this process, I sat there for 4 hours, and it was I have 3 kids with special needs, and it was a very emotional process. I felt like I was being judged. I felt like I was, in back of my mind, like what you're saying, we're making these decisions. We have to do our research. We have to know what, my thing is, I'm trying to protect my child. I'm not trying to take anything away from them. And it's a very emotional thing for somebody to turn around and tell you, do you realize what you're doing, and point your finger at you and tell you, look what you're doing. Look what your decision you're making. And I don't know any better. I'm only trying to do what's best for them.
Absolutely. And I started this before I started recording. I apologize. I said, you might hear like background noise. I have kids of my own. And I know that, as a parent, you want to protect your kids and take care of them for as long as possible. And I will tell you, I don't know who you dealt with when you came in, and I'm sorry that you felt that way. And that's why we try to, I think the reputation we've developed.
It's a very difficult process, because it's not something I want to do. Like, if my kids can make their own decisions, if my daughter's a lot more high functioning than my other 2 kids are, and like, I don't know if I'm doing the right thing, but then I know her maturity level I know she wants things. I know she wants to do things, and she tells me, and I do everything I can in my power
How
to
old is your
help her with
daughter?
those goals.
How old is she?
She's 21 now. She's graduating. Yeah, she's 21. She's graduating from school this year. But I know her, like, her maturity level is not there. I mean, they can just look at her records, look at what it says, and then make the decision. You guys can make the decision, whatever you think is right.
You can
I'll
always
abide by the
apply.
decision.
Listen, you can always apply, right? If you apply, you submit everything, I'll take a look at it and I'll be like, you know what? Maybe 17A is not the right avenue for you. Maybe you should look at Article 81. Maybe you should look at supported decision making New York. Maybe you should look at the power of attorney. That may be
I
best
mean,
for you.
you know,
And I may say, you know what? 17A is the right avenue for you.
So until you look at everything and you know, then they'll make
I take a look at the
decisions that, you know what?
medicals, I take a look at the IEP and the ISP, and then maybe we'll do a conference early on. So I can
Okay.
kind of tell you, like, you know, based on everything I've seen within the past 2 years, this is a classic this, or maybe you should look at this, or maybe there's a less
Okay.
restrictive
I was
need
never
with
given
that.
that option. Like, nobody
I
ever
know.
said to me, "Oh, you could do this." But okay.
Yeah. That's
That
why,
makes me
you
feel a
know,
lot better.
that's why, like I was saying, you know, we're doing things differently now than we have in the past, and we're trying to educate parents as much as possible. And the
Yeah.
surrogate is very, very supportive and very like into guardianship. Sometimes like courts will say, like in various parts of the state, guardianship is like the stepchild of the surrogate's court. It doesn't get that much attention. I will say that the surrogate that we have right now, not to say that the other one didn't, he was also really into guardianship and really very much cared about it. But our current surrogate is really very much in tune. He was, when he was a legislator, he really worked with a lot of different organizations and funding for, you know, people with disabilities and things like that. So he's actually texting me as I was doing this. So I haven't responded to him yet, which, you know, hopefully he'll be okay with
But
that.
now, can I get your email, or do you have my
I actually put my email address in the chat. So if you look at the chat
Okay.
button, you can and you can
Okay.
email me.
Okay. Thank you. I really appreciate
Of
that.
course, of course.
So it all starts with that email address you gave us. We email you, you send us all those papers, and that's how we start.
Yep, that's it. First step is that point of contact.
Okay.
Anybody else?
I had a question.
Sure.
So if we would like to know what the alternatives are and all that stuff, we should just email you so you can send that email you shared with us that has all those attachments so we can now
The
become
alternatives
educated.
are just watching video number 2.
Okay.
Because the alternatives are not like I'm giving you the paperwork for surrogates court if you are going to go through with 17A. The alternatives, which I've mentioned here briefly, and you'll just hear it again in the video, Supported Decision Making New York, which is an organization. It's a pilot program, although I think they didn't get funding because of COVID. I think they lost their funding, but Supported Decision Making New York is an organization. You can still look them up. They still have their website. And they allow their focus is on helping your loved one be able to have a network of support so they don't have to resort to the guardianship. Power of attorney is your other alternative. Healthcare proxy is another alternative, or Article 81 Supreme Court is your final alternative. And those are the ones that you want to take a look at before you
What's
you know
Article 81?
Article 81 is also a guardianship done in Supreme Court where it is it's tailored. They can tailor it. It is more expensive. Like ours is a $20 filing fee. That's it. Theirs is much more involved. They have a court evaluator appointed. They have a guardian ad litem appointed. There's annual checkpoints on it. So you can check that out. I don't speak for Supreme Court and I don't know how their operation runs. So I don't, I don't want to get into that, but I know that legally it is an option. One of the things that we have done also, just so to make you aware, is let's say you're applying for this and your daughter or son is 18 years old and it's a borderline case. One of the things that we've done is we've actually granted temporary guardianship for a number of years. It could be 1 year, 2 years, up to 3 years, where we then reevaluate where you stand after that period has concluded. It's just a couple of days ago, one of the other surrogate courts in, I don't remember the county, they were exploring the issue of temporary guardianship and possibly utilizing up until the age of 25, but they're still doing research on that. So it's something that we may do also in the future, but we've been doing it on our own because we figure nobody's telling us not to. It's not prohibited in the statute. It's not allowed either. So we're kind of just going to go with it until somebody tells us that we're not allowed to. So it's temporary guardianship, gives us the ability to kind of monitor and kind of go back to your case in a few years and see, what, you applied at the age of 18. Now your son or daughter is 21. Is there an improvement? Is there more room for improvement, or not? So
you said the guardianship is mostly medical, but does it automatically include power of attorney also?
no. The power of attorney is completely separate. The
So we
power
would
of
have to
attorney
do
is for
both.
financial. Power of attorney is financial.
Right.
And a healthcare proxy. So what you can do is, if you don't want to do guardianship because you want your
No, but
daughter,
if I do get guardianship,
you don't
if I
need
get
anything.
guardianship,
Yeah.
you don't need power of attorney also. It's part of it.
It's,
Or do I?
but the power of attorney handles finances. So a power of attorney handles finances. So if you're getting guardianship of the person, you're saying that your son or daughter does not have the mental ability to enter into a contract. So you cannot have
Okay. Yeah.
17A
Okay.
and a POA.
Okay.
You are so informative, and we all really appreciate
Of course,
this.
my pleasure.
My son is 16, and when I first came to the school, I'll never forget Bill Kirk. He showed us this big stack that they were working on, and I was like, Lord, I don't ever want to have to do that. And now he's 16, and it's like, okay, we still have a little time, you're saying, not till, right?
time,
There's
yeah.
17 and a half, but get the stuff going. I do want the information from you and the knowledge to be able to read it someday, sometime.
You'll need those 2 years, Zena, just to fill out all the forms.
It's not that bad. Stella, it's not that bad.
Filling it out and then.
She went like this. Come on.
Because it was
That's 2
gigantic.
years. Start now. We gotta
Billy
start now.
Quirk, he's Supreme Court. He never worked in surrogates.
No.
No,
never
but
did.
he was doing it for his own son, and he had it with him to show it. And I was like,
It's maybe like
a little
this. It might be like
scared.
this.
It got smaller. I think.
I'm a teacher, so it reminded me of the comprehensive educational plan. It was almost as thick as that.
It's not that bad. It's not that bad. Well, actually, one of the things that we're doing, so like after we made the YouTube videos, and I have a disclaimer. This has nothing to do with the Office of Court Administration. They didn't sanction this. This is on my own. The Office of Court Administration actually contacted us, and I've been working with them on like simplifying the papers and the websites that go to people who don't have attorneys. So it may actually be broadcast to help families all over the state of New York. It's working out very well. And again, it's, watch the video, have the papers in front of you, and then just go step by step, and you'll be fine. You'll be fine. Do it with a glass of wine. You're not going anywhere. You're not doing anything, right? We're all home. So just do that. You're mute.
You have special needs kids?
We should do it together.
We're home and have nothing to do with special needs.
After they go to sleep. After they go to sleep. I have my husband who's been been at work all day. He's being cordial enough to hang out with my children, our children, until I finish. So
thank you so much for doing this.
We
Thank you.
appreciate you.
Thank you.
so
No
much.
problem.
Thank you for
No problem.
Jillian for doing it and getting
Thank
it
you.
together.
Yes, Jillian.
Jill. Thank you.
Okay.
Good night,
Anything
everybody.
else, guys? Good night. All right.
Thank you
Thank
so
you.
much,
Thank
Irene.
No problem.
so much.
Take care.
Thank
Bye-bye.
you.
Bye.
Bye.
Bye.